Good morning and thank you for joining us today for the From FAIS to COFI, a Financial Advisor's Guide to the Transition webinar. I am Marzaan de Tooy, Regional Manager for the distribution team based in Pretoria, and I'll be your host this morning. Before we get started, some housekeeping. With technology, there can be bugs. So if you experience any technical issues, please use the Zoom help guides or try leaving the webinar and re-entering. You're also welcome to submit questions throughout the duration of this presentation, and you can do so by clicking on the Q&A icon at the bottom of your screen. We'll try to get through as many of the questions that you've submitted, and we'll also get through those received during the registration. So we are in the process of certifying this webinar for continuous professional development hours, and CPD hours will count for the duration that you are logged in. Moving on to the agenda for this morning. So with me today is Reo Emmett, one of our senior legal advisors. Reo will kick off by taking us through COFI and some of the certainties and uncertainties at this stage. We will then conclude with a Q&A session, which I will be facilitating. So let's get on to it. Reo, the floor is yours.
Good morning, everyone. Thank you, Marzaan, for the kind introduction. I do hope you all will find this session fun. As fun as talking about prospective law can be, and informative. I'm sure many of you have heard about the Conduct of Financial Institutions Bill, and more importantly, what it could mean for the industry. Frankly, this is a complex topic to present on, not necessarily because of the effect the legislation is meant to have on the industry, but rather because of the certain level of uncertainty that inherently exists when talking about law that isn't law just yet. I've asked the powers that be to have a giant red disclaimer flash across your screen reading, "Warning, everything you're about to be told is subject to change." They assured me that this would happen. Hopefully, that wasn't just to put me at ease. I'm sure one of the most common questions that will be asked today is, when will COFI come into effect? How much time will I be given to become compliant with the new regulatory landscape? Especially since COFI has been brewing for a number of years already. These aren't questions anybody has truly definitive answers to just yet. National Treasury has indicated, however, that COFI is anticipated to be tabled in Parliament sometime in 2025. Additionally, the Financial Sector Conduct Authority, or FSCA, is preparing for the bill's implementation. More detailed information is said to be available in the FSCA's 3-year regulation plan, an updated version of which will be published later in 2025. The aim of today's session is to talk about the things we, as an industry, do have certainty on. While there are various versions of the bill in circulation, I will attempt to talk about the things that are consistent across all versions of the bill. Today's webinar can be divided into 3 buckets: the road so far, principles-based regulation, and a section I like to call laws. They are changing. We'll cover these 3 buckets by discussing how we got to Twin Peaks, how the industry has been regulated, principles-based regulation, TCF and FAIS, the first taste, COFI's purposes and objectives, activity-based licensing, compliance under COFI, and transformation under COFI. The why of it all. Before we can truly begin talking about COFI, I think it's pertinent that we start with a bit of financial services law history. The promulgation of the Financial Sector Regulation Act, or FSRA, imported an approach to regulation known as Twin Peaks. Is Twin Peaks a concept that is unique to South Africa? Not at all. At the time the FSRA was promulgated, circa 2018, Twin Peaks had already been in place in a number of jurisdictions, such as Australia and the United Kingdom. Australia was actually the first country to implement the Twin Peaks approach to regulation. This happened as early as 1998. What exactly is Twin Peaks and what does it mean for the industry? Well, Twin Peaks is an approach to financial services law that splits out the regulators into two distinct but equally important peaks. One piece is focused on market conduct regulation, how participants behave and treat customers, while the other peak is focused on prudential regulation. Are participants financially sound? In South Africa, these peaks are managed by two regulators, the FSCA and the Prudential Authority. As you can see from the slides, the FSRA's effective date was 1 April 2018. I know what you're thinking, but I promise it was not an April Fool's joke. Broadly speaking, the FSCA's mandate is to ensure that customers are treated fairly by financial institutions, while the Prudential Authority's mandate is to ensure that financial institutions operate as a going concern, so they can continue to exist and treat customers fairly. This webinar will focus on the peak relating to the fair treatment of customers. The fair treatment of customers is at the heart of COFI. So how has the industry been regulated and how is it changing? For the longest time, the industry has been regulated by what is known as a rules-based approach to regulation. This is a fairly simple notion to understand. You open up the relevant piece of legislation and you read the list of things you have to do with a list of things you can't do. And this is how you are regulated. The problem with this approach, of course, is twofold. First, rules don't leave much room for innovation. And secondly, rules by their very nature are reactive. While a rules-based approach may seem simple, it can stifle innovation. Having a list of do's and don'ts does not leave much room for certainty or creativity. Rules are a snapshot of the market at a point in time, and anything truly novel wouldn't be contemplated by said rules. Rules are, at their core, a best guess as to what the future will look like. It's like trying to regulate the weather. You will eventually be caught in a storm without an umbrella. One of the professed aims of COFI is to support innovation. Rules are never a perfect fit to their purpose. They are always over-inclusive or under-inclusive. Like that shirt you bought, one size too small, that you swore you'll fit into by summer. Rules don't give much wiggle room. A rules-based approach is also reactive. Whenever new risks present themselves, the regulator has to amend existing legislation in an attempt to regulate something that was not previously contemplated. Amending legislation is a labor-intensive and time-consuming process. While the process plays out, the harm persists. This detracts from the trust and confidence customers have in the financial services industry. Ultimately, it is argued that a rules-based approach to regulation is not in the best interest of customers. If not rules, then what? Well, COFI's solution is something known as principles-based regulation. I'm sure you're all wondering what exactly is meant by the phrase principles-based regulation. When I first heard of it, I struggled to marry the two concepts. We all know and understand the phrase rules and regulations. Principles and regulations just doesn't have the same ring to it. Broadly speaking, principles-based regulation means moving away from the known, moving away from placing reliance on detailed prescriptive rules and relying more on high-level goals and objectives. These goals and objectives will set the standard against which financial institutions will measure themselves. Does this mean there will never be any more rules for industry to follow? Fortunately not. It is envisioned that the regulator will rely on a blend of principles and rules to ensure market conduct regulation leads to the fair treatment of customers. In the explanatory memorandum to the Conduct of Financial Institutions Bill, published in 2018, the rationale for principles-based regulation is explained by National Treasury as follows. A narrow focus on rigid rules and compliance reporting has often led to the letter of the law being followed, while the spirit of the law is missed. A principles-based approach seeks to set principles that specify the intention of the regulation, rather than set rules detailing requirements of a financial institution. I like to describe principles-based regulation as a destination in your GPS. The GPS could give you 6 different routes to get to your location, and all routes will be equally valid. Just don't go jumping any red robots on your way to your destination, and you'll be fine. The logic behind principles-based regulation is that financial institutions and their management teams are better placed than the regulators to determine what actions and processes are required within their business to achieve a given regulatory objective. A principles-based approach to regulation has the following benefits. Financial institutions will have flexibility on how outcomes and principles are achieved or implemented. As mentioned before, the route is yours. As long as financial institutions keep the best interest of customers in mind, they will have flexibility on how to achieve the specific regulatory objective. Key regulatory decisions will also be made by senior level employees. Deciding the route will be in the purview of senior management. They will decide the approach that should be taken. The approach adopted by the financial institution will be proportional to the size and complexity of the organization. This is aligned to another aspect of COFI, that regulation should be proportional. We can have another hour-long debate on what proportionality means in this space. But the succinct point is this. The bigger your organization, the more complex your structure will be, and therefore the more complex it would be to consistently apply a principle throughout your organization. The inverse is also true. The smaller your organization, the easier it will be to ensure a principle is being complied with consistently. The potential challenges to a principles-based approach to regulation is as follows. There may be a lack of certainty. One of the criticisms of a principles-based approach to regulation is that the industry may not have the comfort of knowing where it stands because a principle may not be sufficiently clear. There may also be a number of guidance notes. Something that may ameliorate the aforementioned challenge of a lack of certainty would be the publication of guidance notes. There is, however, also a risk that the industry could be overwhelmed by the amount of guidance notes and other measures used to provide a level of certainty. Remember, another aim of COFI is to reduce the fragmented approach to regulation. A mass publication of guidance notes and interpretation notes would undermine this approach. And adopting a principles-based approach to regulation requires more skill to develop measures that will meet the outcome of the principle. Principles-based regulation requires financial institutions and regulators alike to focus on the end, something that may be difficult to comprehend at the beginning. Financial institutions will need skilled individuals who are able to understand and articulate the proposed principles and apply that understanding throughout the business. The regulator should always strive to respond to similar situations in a similar manner. Thus, time will invariably provide certainty and ameliorate most of the possible concerns raised above. Once we're past the teething stage, the industry may not be able to understand why we didn't move to a principles-based approach to regulation sooner. At least that's the hope. I'm sure everyone here is familiar with the content of this slide. This slide contains the 6 treating customers fairly outcomes. The outcomes are as follows. Customers can be confident that they are dealing with firms where TCF is central to the corporate culture. Products and services marketed and sold in the retail market are designed to meet the needs of identified customer groups and are targeted accordingly. Customers are provided with clear information and kept appropriately informed before, during, and after the point of sale. Where advice is given, it is suitable and takes account of customer circumstances. Products perform as firms have led customers to expect, and service is of an acceptable standard and as they have been led to expect. Customers do not face unreasonable post-sale barriers imposed by firms to change a product, switch providers, submit a claim, or make a complaint. What we can glean from these 6 outcomes is just that. They are outcomes, not a detailed and prescriptive list of do's and don'ts. The list doesn't contain 6 things that can or can't be done. The list contains outcomes that should be achieved and considered in everything that a financial institution does. This is what COFI is trying to achieve as well. TCF is the precursor to principles-based regulation in the financial services industry. It was the first attempt at inserting a golden thread throughout the broad and all-encompassing regulatory universe. This all started as far back as 2014 already. It's been 11 long years since we first attempted to incorporate principles-based regulation into our regulatory universe. While TCF was the precursor to principles-based regulation, it is not the only attempt to incorporate principles-based regulation. The General Code of Conduct, published under the auspices of FAIS, also attempted to incorporate principles-based regulation into the financial services regulatory universe. More specifically, Section 2 of the General Code of Conduct provides that a provider must, at all times, render financial services honestly, fairly, with due skill, care and diligence, and in the interest of clients and the integrity of the financial services industry. These are overarching principles that FAIS attempts to incorporate into the financial services world. There's no detailed explanation of what constitutes due skill, honesty, or the integrity of the financial services industry. I assume the hope is that these concepts are ones that you recognize by way of exclusion. What I mean by that? I mean you can't pin down these principles. You can't provide an exact definition, but you definitely know when something is dishonest or lacks integrity. The General Code of Conduct then goes on to list specific duties of a financial services provider. The legislation uses the peremptory must. For example, representations must be factually correct. Transactions must be accurately accounted for. Or records must be kept for a period of 5 years after termination. This prescriptive list of things that must be done adds substance and weight to the principle of acting with due skill. This is a great illustration of how COFI intends to operate, namely a blend of principles and rules to supplement the overarching principles. While a lot more can be said about principles-based regulation, this session is not intended to be a deep dive into principles-based regulation. Let us now begin discussing the purpose and objectives of COFI. The object of COFI, as contained in Section 3 of the bill, is to first establish a consolidated regulatory framework. COFI intends to repeal more than 13 pieces of conduct-focused legislation and replace it with a single comprehensive piece of market conduct legislation. The approach currently is immensely fragmented. This adds complexity and inconsistency to the lives of financial institutions. Secondly, the object of COFI is to support the FSCA in achieving its mandate, as set out in the Financial Sector Regulation Act. This is the what component of COFI. It gives the industry a sense of what COFI is here to achieve. You may be asking, why is this important? Section 2 of COFI explicitly provides that whenever you are interpreting COFI, you must interpret and apply the Act in a manner that gives effect to the object of the Act. The object therefore serves as a guide rail, assisting industry in the interpretation of COFI. The purpose of COFI is set out in the preamble of the Act. This is the why component of COFI. It tells us why the Act exists in the first place. Some pertinent purposes include the protection of financial customers, supporting fair, transparent, and efficient financial markets, promoting trust and confidence in the financial sector, promoting financial inclusion, and promoting transformation in the financial sector. These purposes are aligned to the overarching objectives of the FSCA, as contained in Section 57 of the FSRA. These should be kept in mind when you are trying to interpret and apply the principles contained in COFI. Now that we have a sense of what COFI is trying to achieve, as well as a deepened understanding of why COFI is needed, we should spend some time figuring out how COFI intends to achieve these ambitious objectives. COFI will introduce a new approach to market conduct regulation that is proportional, risk-based, outcomes-focused, and principles-based. It will also shift away from a licensing regime that focuses on institutional form to a regime that focuses on the activity a financial institution performs, something we'll discuss next. As mentioned earlier, a principles-based approach does not mean a complete absence of rules. It is well recognized that the financial services industry requires an appropriate mix of principles and rules in order to achieve the correct outcomes. Rules may be required to protect highly vulnerable customers or to respond to sustained egregious behaviors and practices. A move to principles-based regulation also shifts the onus. Currently, with a rules-based approach to regulation, the onus is on the regulator to ensure that the rules are followed. With a principles-based approach, however, the onus is on the FSP to ensure that principles are applied and the desired outcomes are reached. Outcomes-focused means that the yardstick for success is shifted from, is this box ticked, to, did this have the desired effect on customers? This approach ensures remedial action is taken when poor outcomes are in fact produced. This is different to the current approach, where periodic supervisory assessment checks compliance with the letter of the law, and where identifying and remedying poor outcomes can be a slow and inefficient process. A proportionate and risk-based framework to regulation should enable the regulator to identify areas that pose the greatest market conduct risk and use proportionate regulatory capacity to address these risks. How does a risk-based approach differ to the current status quo? Well, a risk-based approach will require the regulator and financial institutions alike to be forward-looking and to have the skills and the resources to identify, collect, and analyze market information and trends. Proportionality should also influence the regulator's supervisory approach. The content of the standards the regulator sets and the enforcement action it takes in respect of different categories of financial institutions and the risk that they pose to the financial services industry. COFI amplifies and extends the principles of market conduct regulation that FAIS introduced. We must not get things confused though. COFI is not simply a repacked restatement of FAIS. It is a lot more than that. COFI is a comprehensive overhaul of South Africa's financial sector regulation. It is intended to streamline oversight and promote trust in financial institutions. It's not a new coat of paint on an old car. It's an entirely different model, and maybe even brand. The impact of the licensing framework will also vary between smaller and larger institutions. COFI requires licensed financial institutions to have governance arrangements proportionate to the nature, size, and complexity of the risk that the financial institution poses. Assessing the risk a financial institution poses will involve scrutinizing the business model and activities a financial institution is licensed to perform. COFI emphasizes proportionality. Currently, there are about 13 financial sector laws. These laws regulate and supervise financial institutions based on their institutional form or definition. What does that mean? If an institution is defined as a long-term or life insurer, for example, the conduct rules applicable to the insurer are contained in the Long-Term Insurance Act, as well as the Insurance Act, and other pieces of subordinate legislation, like guidance notes and conduct standards. Put differently, the laws that govern you are linked to the institutional form you take. Are you an insurer, a bank, a pension fund, etc.? This has resulted in a silo approach to regulation, where each type of financial institution exists in its own little regulatory universe, with unique but similar laws and obligations. This doesn't always redound to the benefit of customers. Customers don't engage with financial institutions based on their institutional form. They engage with you as a brand. They don't draw a distinction between the product provider and the lisp in your group of companies. The current approach to regulation has also led to a lack of consistency. As the lawyers in the room will attest to, if there are any, in law, every word and every comma matters. Sometimes the intention behind a provision contained in FAIS and a provision contained in CISCA is identical. But because the wording is slightly different, the obligations placed on the FSP and the MANCO are different. This lack of consistency is tricky for a group of financial institutions to navigate. Another unintentional consequence of the fragmented approach to regulation is the ability to escape the regulatory net. What does that mean? It means that in some places, the hole in the net is bigger than the fish the legislation is trying to catch. The problem with regulation based on institutional form is that if you only satisfy 80% of the definition of a specific financial institution, you can argue that you are in fact not that financial institution and therefore aren't subject to regulation. A classic example of this, from the regulator's perspective, is the giving of advice on cryptocurrency. The definition of cryptocurrency didn't fit into any of the traditional financial product definitions in FAIS. However, it looked like a financial product, it walked like a financial product, but it didn't exactly talk like a financial product. So it escaped the regulatory net until such time as the FSCA declared it to be a financial product. Declaring something to be a financial product is a long and involved legislative process. It's not all doom and gloom. These 4 issues do have a possible solution, and that solution is activity-based licensing under COFI. First, COFI is intended to repeal several pieces of conduct-focused legislation. This will significantly cut down and streamline the current regulatory universe. The fragmented approach to regulation will be a thing of the past. COFI will effectively exist as the one law to rule them all. Secondly, COFI will shift away from the silo approach to regulation by transitioning towards activity-based licensing. With this regime, it doesn't matter what institutional form you take, you will require a license for the activities you perform. Financial institutions will no longer have to look to multiple pieces of legislation when they perform multiple activities. This will be especially helpful to big groups which have a number of different financial institutions in their stable. Thirdly, similar activities will be regulated and supervised in a similar manner, regardless of the type of financial institution performing the activity. This means that consistent requirements will be set out in a single law. This will close the gap in the current legislative fishnet, where some activities that otherwise should constitute financial services can escape regulatory oversight because the entity providing the service doesn't fit into institutional definitions. Finally, COFI will promote a level regulatory playing field for financial institutions and bring more consumers under the protective regulatory net. How will it level the playing field? By relying on proportionality. Proportionality is important to create a more level playing field for financial institutions of different sizes, because different sized financial institutions bring about a different level of risk to customers and to the financial sector. This approach can reduce regulatory barriers to entry and also support transformation of the financial services industry. You can really see TCF's influence on COFI when you go through the different chapter headings. For example, one of COFI's chapters is titled Culture and Governance. This is clearly reminiscent and inspired by TCF Outcome 1. Another chapter is titled Post-Sale Barriers and Obligations. This sounds very similar to TCF Outcome 6. Let's now take a moment to understand how licensing will work when the industry transitions to COFI. It is assumed that COFI will be promulgated but given a delayed effective date. This will achieve the goal of publishing a finalized piece of legislation for the industry to study and get to grips with, while also ensuring that regulators have sufficient time to deal with the conversion or reissuing of licenses. There are two broad categories of people that will require a license under COFI. First, there is a group of people who are performing a financial service that is already regulated, such as financial advisors or collective investment scheme management companies. For this group of people, COFI provides that they will continue to exist as a licensed financial institution in terms of the previous act, think FAIS or CISCA, as if it had been licensed under COFI and authorized to perform an activity or sub-activity that is similar to the business for which it is currently licensed. In other words, once COFI is effective, all institutions who are already licensed continue as is until they are granted a license under COFI. The second category of people are those whose activities or sub-activities did not require a license under any previous financial sector law. A classic example of this would be corporate advisory services. COFI defines corporate advisory services to mean providing proposals or guidance in respect of a company's change in share capital, mergers, and acquisitions. This activity previously did not require a license since it wasn't considered as providing financial advice under FAIS. Why wasn't it considered providing financial advice under FAIS? Because financial advice is only relevant insofar as it relates to advice given in respect of a financial product. A company's own share capital is not a financial product. For these people, COFI is proposing to give them 4 months after the effective date, not publication date, to obtain a license under COFI. These people will be allowed to continue performing their activities for the duration of the 4-month period. Schedule 1 of COFI contains categories and subcategories of activities requiring a license. COFI breaks down financial products and services into activities and sub-activities. For example, one activity is known as providing a financial product. Under this activity, you could perform up to 7 different sub-activities. The sub-activities include providing a participatory interest in a collective investment scheme, providing a life policy or non-life insurance policy, or providing retirement fund benefits. A financial institution is licensed to provide a financial product, and the license will list all the sub-activities a financial institution is licensed to perform. This is another great example of how activity-based licensing is meant to work. As you can tell from the list, those are all very different financial products, currently regulated very differently. In the epoch of COFI, however, they all fall under one umbrella term, providing a financial product. And they should all be regulated similarly, with some deviation for nuances. As mentioned earlier, COFI amplifies and extends the principles of market conduct regulation introduced by FAIS. It truly acts as a comprehensive overhaul of South Africa's financial sector, designed to streamline oversight and promote fairness. COFI's broader scope makes it more than merely an enhanced version of FAIS. The impact of the licensing framework will also vary between smaller and larger financial institutions. COFI requires licensed financial institutions to have governance arrangements proportionate to the nature, size, and complexity of the conduct risk, business model, or activities a financial institution performs. Let's now briefly discuss advice under COFI. More accurately, we will start with advice under FAIS. Under FAIS, the provision of advice is defined to mean, amongst other things, any recommendation, guidance, or proposal of a financial nature furnished by any means or medium to any client or group of clients. Advice was relevant to the purchase, investment, acquisition of any right or any benefit in a financial product. Advice also included the variation, replacement, or termination of a financial product. Advice under FAIS also did not give any weight to whether or not a financial product was actually purchased. In other words, even if a client decided not to invest in a specific product, the information provided would still constitute the activity of providing advice. The definition under FAIS is very broad. COFI expands the definition of advice slightly, but it will not result in what constitutes advice changing materially. First, unlike FAIS, COFI isn't limited to advice insofar as it relates to a financial product. For COFI, advice is advice if it relates to a financial product, a financial instrument, foreign exchange, payment system, or asset class. Asset class will be defined in COFI, while financial instrument is currently defined in the FSRA. A number of pertinent COFI definitions sit in the FSRA. The FSRA's definition of financial product and financial instrument amounts to a near identical copy of financial product under FAIS. Under COFI, the allocation of an investment or part of an investment in a financial product or financial instrument constitutes advice. This sounds like it is an attempt to ensure that advice relevant to model portfolio construction is captured in the advice regulatory net. I think that a more important distinction between FAIS and COFI is the subject of financial advice. Under FAIS, client has a specific meaning, and more importantly, it excludes the general public. In COFI, advice is defined as any proposal or recommendation to any person or group of persons. Why is this distinction important? Currently, certain individuals manage to escape the regulatory net by giving advice online to the general public. Think of an Instagram or TikTok video with links to invest in something. Currently, this doesn't constitute advice because it is given to the general public, a category of person that FAIS currently excludes. COFI uses the word person, which should include everyone. It will be interesting to see how this change will be managed and enforced. COFI also introduces a shift from registration to licensing for the likes of retirement funds. It is proposed that retirement funds will be required to be licensed under both the FSRA and the Retirement Funds Act. That will be the new name of the Pension Funds Act once COFI is promulgated. This can be considered the conduct license and is subject to the requirements of both laws. So, in other words, a retirement fund would be subject to both the FSRA as well as the Pension Funds Act, which will now be renamed the Retirement Funds Act. This is to ensure consistency of treatment of members of retirement funds. This can be seen as two keys to financial institutions. It will be a prudential key for prudentially regulated institutions, such as retirement funds, banks, and insurers, as well as a conduct key. However, the licensing process will be streamlined for prudentially regulated institutions, so that they will only be required to submit one application. On the topic of Omni-CBR, the Financial Sector Conduct Authority is slowly introducing a new off-site monitoring tool known as Omni-CBR, or Conduct of Business Return. This will change the way financial services providers report and comply with regulations. Omni-CBR is designed to improve transparency and ensure better outcomes for consumers, focusing particularly on treating customers fairly. This is another precursor to COFI. The cross-cutting nature of Omni-CBR is inspired by COFI's move away from regulation and reporting on an institutional basis. Omni-CBR will require financial institutions such as FSPs, banks, insurers, investment providers, and others to submit detailed reports to the FSCA every quarter. These reports will provide data on conduct indicators, allowing the FSCA to assess whether financial institutions are delivering fair outcomes to their customers. The FSCA aims to use Omni-CBR to address shortcomings in past reporting systems. Traditional methods allowed FSPs to technically comply with regulations without truly reflecting their commitment to TCF. Omni-CBR is designed to encourage FSPs to provide and prove that they are prioritizing fair customer outcomes. Additionally, the FSCA will be able to analyze the data to identify industry outliers and allocate resources more effectively, addressing potential misconduct swiftly. For example, they must now provide specifics on affiliated parties, financial arrangements, and conflict of interest, rather than simply answering yes or no to broad questions. This deeper level of detail will allow the FSCA to assess practices more thoroughly and ensure compliance with TCF standards. Advisors will thus need to ensure that they are collecting and reporting the correct data, which may involve adjusting existing compliance systems. Additionally, adopting to a new reporting framework could initially increase administrative burdens. Omni-CBR will be phased in over several years. Currently, the Omni-CBR template is undergoing revision in response to industry comments. Under FAIS, the FSCA can grant exemptions from the Act, but only in very limited instances. The exemption needs to meet specific conditions, such as promoting fairness and avoiding prejudice. The exemption from any provision of FAIS must not conflict with the public interest or frustrate the achievement of the objects of FAIS. COFI provides the FSCA with broader powers to grant exemptions. The FSCA can now grant exemptions to financial institutions if the exemption will promote the proportional application of COFI or for the development of financial inclusion and transformation objectives of COFI. Of course, doing so must promote the progressive or incremental compliance with the Act by the financial institution. From the phrasing of those two exemptions, it is clear that it is not a blanket exemption. The exemption exists to allow entrance into the market on condition that they will slowly become fully compliant. This provision is important as it may provide some relief for financial advisors who find some of the other requirements of COFI to be prejudicially onerous and contrary to the objectives of financial inclusion. COFI is a piece of legislation designed to regulate how financial institutions operate in South Africa. The main goal of COFI is to protect financial customers, build trust in the financial sector, and promote financial inclusion. The Act is intended to make the financial services sector more transparent, ethical, and accountable. COFI seeks to address the most important aspects of FAIS, including the codes of conduct and the fit and proper requirements for financial services providers. It is expected that any issues not fully addressed in COFI will be covered by additional conduct standards, which may result in additional compliance burdens. This does not mean that we should throw out our entire collective knowledge base. The principles under FAIS are well established and have gone through decades of refinement. The aim is not to throw those out. Instead, the aim is to unify the decades of refinement and growth that financial services law has experienced. I believe a number of the provisions of the General Code of Conduct and the fit and proper requirements will be restated almost identically under COFI. Section 7 of COFI requires financial institutions and advisors to have processes in place to ensure ongoing compliance with the Act. They must also identify and report any non-compliance. While FAIS does not explicitly require financial advisors to set up these arrangements, FAIS does require firms to have multiple key individuals or representatives to appoint a compliance officer to oversee compliance. Many financial advisors, especially those in larger firms, may already have these arrangements in place. However, smaller firms or sole proprietors may need to set up compliance measures to meet the new COFI requirements. Additionally, COFI allows the FSCA to mandate an independent review of a financial institution's compliance processes, and the cost of this review must be covered by the financial institution. If the FSCA finds serious non-compliance, it can take direct and severe corrective actions immediately. COFI requires financial institutions to establish and promote a business culture that treats customers fairly and ensures that products are designed and marketed to meet customer needs. This is a clear legislative restatement of TCF Outcome 1, now with the full force of the law and threat of sanctions. This includes ensuring that marketing material is suitable for the target audience, that customers receive clear information before, during, and after receiving services, and that there are no unreasonable barriers to accessing or terminating financial products. The governing body or board of directors where a financial institution takes the form of a company will be held accountable for ensuring that the company complies with these standards, and they must regularly monitor and review the effectiveness of their governance arrangements. Under COFI, advisors must take more steps to ensure that their services meet the needs of entire groups of clients, such as pension funds, medical schemes, and employer groups. This includes making sure that the financial products and services provided are appropriate for the members or employers of those groups. Section 13, subsection 2 of COFI is stricter than FAIS, in that it requires advisors to take steps to ensure that members of these groups are treated as if they were direct financial customers of the institution itself. This requirement could pose challenges for advisors, especially when it comes to understanding and meeting the diverse needs of a group of members. However, the industry groups like ASISA have raised concerns about this provision, and it may be amended before the final version of the law is passed. While FAIS encourages advisors to have written agreements with clients about their services, COFI makes this a mandatory requirement. COFI states that all financial institutions must enter into a written agreement with each customer. This agreement should outline the nature of the services provided, the terms of the relationship, and the customer's rights, including how to terminate the contract if needed. This change ensures that there is more transparency in the relationship between the financial advisor and their clients. COFI requires financial institutions to regularly monitor and review their financial services to ensure that they are performing as promised and meeting customer expectations. COFI outlines specific factors that must be considered when reviewing these services. If the institution identifies risks, it must take action to mitigate them. Additionally, COFI requires financial institutions to set up mechanisms to oversee the design, development, and the provision of services, ensuring that they remain appropriate for customer needs. COFI introduces rules to prevent financial institutions from making it difficult for customers to hold them accountable for failing to meet expectations or failing to honor contractual obligations. It also ensures that customers can switch institutions, change financial products, or terminate their services without facing unreasonable barriers or high fees. Another legislative restatement of a TCF outcome. Financial institutions will be required to have systems in place for handling complaints and ensuring that claims are processed quickly and fairly. Financial institutions must ensure that financial products and services are appropriately flexible and portable. They must ensure that customers have access to an efficient and effective complaints management process, and that the financial institution has systems in place to monitor complaints and processes that enable the financial institution to proactively identify and manage conduct risks to effect improved financial outcomes on the customers, and to prevent recurrences of poor outcomes and errors. COFI also reinforces the obligations financial advisors already have under the Financial Intelligence Center Act to prevent money laundering and terrorist financing. COFI reminds financial institutions that they must have the necessary systems and policies to comply with FICA and related anti-money laundering laws. A failure to comply with FICA is now also a failure to comply with the legislation under which an institution is licensed. Financial institutions must also maintain internal controls and procedures to manage risks related to IT security, data protection, and physical security. This includes ensuring proper staff training and preparing for potential business disruptions. COFI aims to support transformation within the financial sector by requiring all financial institutions to have a transformation plan in place. It makes the transformation of the financial sector a clear responsibility of the FSCA, which can take action against firms that fail to follow their transformation plan. The FSCA published a draft strategy for transformation in 2022, which proposed that financial services providers with revenue over 10 million must meet a minimum level of broad-based Black economic empowerment. However, this proposal has been criticized, and the FSCA has stated that they will not apply a one-size-fits-all approach going forward. The FSCA has said it intends following a two-stage approach to transformation. Stage 1 will involve driving transformation within the current regime. Stage 2 will involve relying on the enhanced provisions of COFI to ensure transformation plans are reasonable and complied with. At this stage, it seems unlikely that transformation will negatively affect one's ability to be issued a license under COFI. Instead, it appears that COFI could be applied proportionally to a fledgling institution that is promoting transformation. Today has definitely been a really meaty session. I hope everyone enjoyed the presentation and gained a better understanding of our future under the one law to rule them all. I think, in summary, COFI will introduce several new obligations, including stricter compliance processes and business governance standards. These changes are designed to create a more ethical and customer-focused financial services industry. However, some provisions, particularly those related to advising groups of clients and transformation, may pose challenges and could be subject to revision before the final law is enacted. Thank you for your time. We are now going to do some quick studio magic and set up the room for a quick Q&A.
Thank you so much for that insightful presentation, Reo. My inbox is brimming with questions, so I would really like to dive in and hopefully get through as many of them as possible. Yeah. So it does seem that the one certainty is that it's uncertain when COFI will be implemented. What can we tell advisors to do at this point? How can they prepare themselves and their businesses while waiting and facing this uncertainty?
Well, I do think that the last version of the bill is pretty close to a finalized version. Remember, the core thing that advisors need to do now is adjust to principles-based and outcomes-focused. But in all honesty, as long as advisors keep customers and the fair treatment of customers in the back of their mind, I think they're doing all that they need to do at this point. The rest of the systems-wise and the compliance under COFI, you'll have more clarity on when COFI is promulgated. And we mustn't forget there's going to be that lag between promulgation and effective date. That will really give advisors time to design their systems according to the finalized compliance obligations. But keeping customers in mind when you do everything, that's really all you need to do for now.
Thanks. Something else that bubbled up quite a few times is whether we think it's going to be necessary for advisors or businesses to do any new form of licensing. Will it be required to rewrite any of the regulatory exams? Do we have any clarity on that aspect?
The bill doesn't provide too much certainty there, but the idea is to definitely get new licenses, COFI licenses, because currently you have a license as an FSP, that's your license. Now you will be applying for a license to do a specific activity and various sub-activities. You may not want to do all 12 of the sub-activities under one activity. So there will definitely be a relicensing process. But it's important to remember that COFI says, carry on as you are. That will all happen in the background, so to speak. It will definitely be a reapplying for license. With regard to the RE exams, there isn't any true clarity just yet, but as I understand it, the fit and proper requirements are meant to be restated very, very similarly under COFI. So it wouldn't make sense to rewrite RE exams on the same information, if that makes sense.
Okay. So working with advisors in distribution, one of the things that I often hear is how onerous the regulatory burden is on them already. You mentioned in your presentation that there is currently 13 different financial sector laws and that COFI will repeal some of them. What do you think will the impact be on the regulatory burden that advisors experience, and why do you say so?
I'm an optimist. I am hoping that this will reduce the overall regulatory burden. As a person that works in the legal field, I can tell you it's very burdensome to have to check 13 separate laws and 13 separate sets of regulations under each laws and 13 different guidance notes to be able to answer a question on what can and can't be done. So I'm hoping that COFI, as an optimist, will simplify that process. You will have one, as I said, one law to rule them all, one place to check. But as mentioned in the previous question, everything continues as normal. So even though COFI will repeal all those laws will continue to exist and apply until a new COFI license is issued to the advisor. So in that interim period, I think it's going to be slightly burdensome. Because you're going to have to be complying with the laws you know, while at the same time trying to comply with this new law that you're learning. But once the teething phase is over, I am really hopeful that it will be a simplified process, mainly because you'll only have one place to check.
This is also something that you touched on in your presentation, and I'm hoping that we can go into a little more detail. So, do we foresee any changes around the challenges that clients face when they want to transfer to a new service provider? Examples being the hefty penalties or the inability to transfer an endowment.
The transferring an endowment is an interesting question. That's also more focused on prudential regulation. Remember, it's the Insurance Act that limits the ability of an insurer to transfer their business. So that notion of being able to transfer an endowment is really something that's in the purview of the Prudential Authority. The risk with transferring insurance business is that there's customers that fall out, that lose their benefits or their rights, or you contract with one insurer that you know to be large and that has the assets to back your product, and they transfer that business to a slightly small insurer who might not have the same financial backing to comply with obligations under that endowment. So I know there is this idea that that's something that they want to achieve, but that's not something specifically that COFI will be trying to achieve. On an aside though, COFI does say that they want the products and services to be more portable so that you aren't locked in to any type of product if the service just isn't up to scratch or if it's detrimental to you. From a penalties perspective, I definitely think penalties for transferring products or terminating your relationship with the advisor, I think that will become a relic of the past. Because as TCF, the TCF outcomes state, there should be no post-sale barriers. And locking a client in under threat of penalty is definitely a post-sale barrier. That being said, usually those penalties exist for a specific reason. Usually those aren't actually there to punish clients. It's more a manner to ensure that the costs that you would face up front are spread out over time, so it's not too burdensome. So it's going to be interesting to see how we manage those two interests. You want the client to be onboarded in a cost-effective manner, and the easiest way to do that is to spread out costs over time. But you also want the customer to be able to say, I'm not happy here, I want the same type of product, but somewhere else.
One of the questions which seem to have some contradicting views is whether we think would our advisors would need to recontract. So where they've got existing contracts with clients, you talk about rules and regulations is now principles and regulations. Would they have to recontract based on this principles and regulations contract that they would now have with clients?
I think any written contract, remember COFI requires you to have a written contract with your client. As long as one exists, I don't think there's a need to recontract specifically. Remember, the contract encapsulates the law that applies. So if you think about the relationship between the advisor and the client, it usually captures the laws that currently apply. When COFI changes, these principles and regulations apply to this relationship, not because the contract says so, but because the law says these principles and regulation must apply.
Okay.
So I don't think there's a need. People may want to spoof up their mandate, want to make things more clear, and there are other methods of incorporating this legislation through terms and conditions documents that are more flexible.
Okay. There's been a lot of questions coming through around the impact of this on smaller businesses. So my question is, how do you see this playing out for a smaller business? Is there any advice, any tips that you can share for the smaller business owners at this stage to better prepare themselves?
I am definitely sensitive to the needs of smaller businesses, and I think that the regulation is too. Remember, COFI emphasizes proportionality. So while there are these big onerous rules and regulations and principles and regulations that need to be applied, COFI's main aim is to make sure that these rules and these principles apply proportionally to the risk that you actually contribute to the industry. So if you're a smaller practice with fewer clients, those clients aren't less important, but you pose less systemic risk to the entire industry over time. So the idea is that those institutions, those financial institutions, will have possibly a little more time to get to grips with this, because that would be truly applying COFI proportionally. And again, like I said in the presentation, it does not mean that you get this exemption and you can go on and just stay as you are. The exemption exists to allow you time to comply with these rules.
Okay.
But compliance is becoming more onerous. There's no escaping that.
Reo, one of the questions that came through, is COFI really necessary? Should we be doing this? Is this the right thing for the industry to be doing?
I think when you're driving down a road that already has potholes and you've been driving down that road for so long, you forget that the potholes are there. They just become little bumps on your journey that you're so used to. And I think the same is true when it comes to COFI. We've become so accustomed to the gaps and issues that exist in the regulated universe because we still manage to comply, we still manage to treat customers fairly, that it feels like this is unnecessary. But I do think that this fragmented approach to regulation is complex and not in the best interest of customers. I think unifying the law is ultimately a good thing. Giving businesses free range to decide how they want to get to a certain principle and how they want to apply it, I think that's a good thing that will make life easier for them also. Because now you look at your business and how you need to get to this point, not how multi-billion rand business is getting to this point. You can decide your own route. So I think change is always scary, but I do think that this is necessary and useful for the industry.
Thanks, Reo. Does COFI make any mention of the remuneration structure of advisors?
Not explicitly in the Act. I think remuneration is going to be covered under guidance notes, but I don't think it should be too dissimilar to how remuneration is currently dealt with, which mainly means not being remunerated for the same service more than once. So I think that's how remuneration will continue to apply going forward. It's fair, reasonable, and commensurate to the activity and the service you actually perform.
Okay. Then if we think of the additional burden of implementation on a practice level, how do you think COFI will impact practice management within FSPs going forward?
Well, I think your time might have to be split slightly. The sole focus can't be just on providing advice anymore. I think compliance is going to become a peak, like the Twin Peaks, that is almost equal in value to the advice that you provide. And this hand will support this hand. Compliance will support the advice you give. And good quality advice that is aligned to customers, to treating customers fairly and the outcomes, is going to support and make compliance with COFI easier. So I think you'll do more than just running an advice business. You'll now be running an advice business that focuses on outcomes. So you always have to keep the end in mind with whatever you do, which could be new and possibly fun.
On a slightly off-topic angle, when we think of two-pot, overall I think the industry did a really great job in informing and educating advisors and clients. So this will be my last question to you. Should advisors be talking to their end clients about these coming changes, and what should the core message be?
I think it's always great to inform your clients that things will be changing, so they can also understand when advisors come to them and say, I need more information because I need to collect and analyze so I can report this to the FSA. You want clients to understand why this is being done. You don't merely want the FSP to be a conduit for the law. You want it to be the person that explains the law and the rationale for the clients. And I think the core message should be, this is all in your best interest. It's all to make sure you are treated fairly by me and by everybody in the industry, and that we'll navigate this together.
Thank you for that, Reo. That concludes our webinar. To our advisors, your feedback is extremely important to us. So after the webinar, a survey will pop up, and we ask that you please take a few minutes to complete this. Then lastly, to all our listeners, thank you for joining us this morning. We hope that you found this webinar valuable, and we look forward to journey with you on this transition from FAIS to COFI.